I'm Annie Abrams.
You turn your microphone on by flipping the switch up? Yes.
I'm Annie Abrams, and I'm speaking for myself.
Okay, you're recognized.
I've been known as an advocate for human rights for over 50 years publicly. And I've always been there to embrace people who other folks reject. Be they homeless, be they people with AIDS, be they people who people call gay. The thing that I know is that being heterosexual doesn't give you a good housekeeping seal that you'll be a good parent. I've been out here, I have friends, I have children who are not gay, but they have friends who are gay. And I've been a friend to many, many gays for over 50 years. And I found that many times they're better friends. They are more talented, they're more giving, they're more caring than a lot of heterosexual people that I know. Now I fight for those heterosexuals when they are in the place where I know that they're not in the best interest of humanity. So I hate to see us get to a point. And the reason why it was so important for, I think, for me to come today was that there's a stigmatism that comes if you put the label on somebody that they're gay. Well, I've had a stigma that I can't hide. I can't put no kind of stamp on my dress or pin to say who I am not. I am an African American. I am a female. You don't have to check it, I can tell you. And I feel that we who are not gay have as much responsibility, and particularly in the black community. I know what it means. I tell people all the time, you need to watch the Holocaust. You need to know about what's happening in Africa. That's why I'm going, so that I can preach what I know rather than somebody's statistics. I don't have to check those statistics that were up there. I know from my experience that people come in all colors, they come in all ages, they come in all races. And there's a heterosexual identification that I think that we should never tell people, if I can't check you out, personally, you have no right to human rights in this country. That's why I came today. I didn't want anybody to think this is a white issue. I didn't want them to think it was a gay issue. I want you to think of, if it's you, would you want somebody to stigmatize, oppress you, and deny you the right to life, liberty, and the pursuit of happiness?
Thank you, Mr. Chairman. Members, I won't take all that time. I do want to address some of the points that were raised, though. Representative Powers asked if our state agencies were doing a good job in kind of weeding through the applicants out there. And I just want to point out that the only reason we're here again is because the state agency was doing this very thing, but they didn't have the legislative authority to do it. And the court ruled so. Representative Harrelson, with respect to the issue of how we define cohabitating, we took that directly from the Utah statute, where it said cohabitating means residing with another person and being involved in a sexual relationship with that person. Again, we're not going in to check out your bedroom. We're taking you on faith that the facts that you put forth are true, unless there's somebody to challenge those facts. With respect to the point that Ms. Adcock raised on what other qualifications or what other limitations we place on people who are either prospective adoptive or foster parents. She raises a good point, and it goes back to the issue that I believe Representative Johnson asked earlier. If someone had a homosexual encounter years ago, but they're not currently practicing, how does that fit in? Well, what if we have someone that's a sex offender from years ago, but we can say now we ought to be able to evaluate and see if they're an okay person? What if someone has a drug conviction? They're not currently a drug dealer, but maybe they have a drug conviction. We look at their criminal background. What if someone's just too poor to provide for the child? I mean, there are a lot of very loving people, a lot of very loving families that are very poor. But we look at their finances to determine whether or not it's in the best interest to place them with that child, that child with that family. It was said that we had a trial in Arkansas on whether or not gay people were good parents. And I would submit to you, we did not have a trial in Arkansas on whether or not gay people were good parents. We had a trial in Arkansas on whether or not an executive branch agency had the authority to implement a rule that they had. Now, I will say this. Our statute that we're proposing here does not go as far as the rule that the Child Welfare Agency Review Board had. Their rule said that if you have a homosexual living in the household, you can't place the child there. We're only restricting this to the adoptive or foster parent themselves. I just want to make sure that that's clear for everybody. With respect to the findings of fact, I mentioned them in my opening. The court made a number of findings of fact based on testimony that was given. But again, it was very clear that those findings of fact were specifically related to the issue of whether or not the executive branch agency was acting within the scope of the power delegated to it by this body. And it said that they were not acting in that scope, and it said that they usurped a legislative function. Ladies and gentlemen, it's our job to determine this policy. It's not an executive branch agency's job. We had testimony here that I want to make sure doesn't confuse the facts. We had testimony here by people, and they did a good job of giving explanations of their personal scenarios. But in those scenarios, we were dealing with people that had blood relationships that were either a natural parent-child relationship or grandparent-child relationship. And with the amendment that we have, even for the homosexual side of this bill, it would not affect it if they had that relationship to the child. Again, the issue of guardianship and custody are in no way hampered or affected here. If you want to leave through your will your children in the care under a guardianship order to someone who's a homosexual or someone who's cohabitating, you can do that. And this in no way limits your ability to do that. What this all boils down to is kids in two situations. Kids that have been through some traumatic event and they're put in a position where they're going into foster care. And if we're going to place you with relatives, it's one thing. If we're going to place you with a stranger as a child, we have a higher burden to make sure that we understand that we're acting in the best interest of that child going into foster care. And the other thing this deals with is the adoptive care, which is the permanent placement and the permanent severing of all ties to your previous family. Those are different and distinguished from guardianship, from custody, from all other things. Florida has been challenged 3 times, most recently in 2004. The Court of Appeals was very clear on that. I don't believe we have a constitutional problem in doing this, based on what we've had decided here and what we've had decided in the highest federal court that's dealt with it, in which the U.S. Supreme Court denied cert and let the ruling stand. There are experts on both sides. With the body of evidence, the American College of Pediatricians is contrary to some of the other folks that were listed on that list earlier. There are the Institute of Marriage and Public Policy. A number of groups have done studies, have provided evidence, and arguments can be made on both sides. But what it comes down to right now is our responsibility as the elected lawmakers, public policy makers of the state of Arkansas. And with that, Mr. Chairman, I would close. I would thank the chair, the members of the committee, and everyone who's been involved in this debate from the very beginning. This is something that's very emotional and could easily get out of hand, but the tone has been generally very, very good, and I appreciate that from all sides. Thank you.
Thank you, Senator.